Hello, everyone. Welcome. Shall we get started? Welcome to Researcher Access in the DSA, State of Play and Next Steps. I'm Brandy Gerkink. I am the Executive Director of the Coalition for Independent Technology Research, which is a coalition of more than 450 independent researchers across 40 different countries who work together to advance, defend, and sustain the right to ethically study the impacts of technology on society. And 4-ish years ago, there was a similar panel to this one here at CPDP talking about researchers and data access. And I think that this really shows that there's been a long recognition that researchers play a critical role in understanding and raising risks associated with the use of digital technologies and evaluating mitigations that are put in place by companies that operate those technologies. So we've come, I don't know if we've come a long way in the last 4 years. I think in some ways we have. I suppose that's what we're going to talk about. Over the last year in particular, there's been a few different steps that have been already taken on implementation of data access within the Digital Services Act. So for public data, for example, platforms are, in theory, processing applications from researchers for access to that data. The European Commission has launched investigations into platforms' compliance with different provisions of Article 40. And for non-public data, there's a delegated regulation, which many of you might be familiar with, which promises to empower even more detailed investigations from the research community. So I think the big question, at least on my mind, and I hope we're going to get into over the next 75 minutes, is what of this is working, what's not working, what is the current state of play on many of these open questions. So I'd like to introduce now our esteemed panel. We have Matthias Vermeulen, who's a co-founder and director of AWO, a law firm and strategy consultancy specializing in AI, data protection, online safety, and other digital policy topics. We have Kirsty Park, who is the Assistant Director of Research at Commission Naman, Ireland's media regulator and digital services coordinator. And Kirsty's work focuses on the implementation of the vetted researcher provisions under Article 40 of the DSA. We have Patty Learson, who also organized this panel, and thank you for bringing us together, Patty, who is a postdoctoral researcher in law at the University of Amsterdam's Institute for Information Law. Patty's research focuses on social media governance with a particular emphasis on questions of transparency and data access. And Patty is part of the DSA Observatory Project, which monitors the implementation of the EU's Digital Services Act. And we also have Elka Zeiling, who has an academic background in psychology, cognitive systems, and human factors, and is currently responsible for coordination of the DSA 40 Data Access Collaboratory, which is a joint project by the European New School of Digital Studies and the Weizenbaum Institute. So I'd like to first turn it over to you, actually, Elka, to talk to us a little bit about Article 40.12, which focuses on access to public data under the DSA. Can you tell us sort of tell us a little bit about Article 40.12 in case there's people in the room not familiar with it? And how are things going for the research community? How is this working or how is it not working?
Okay, yeah, thanks, Brandy. So Article 40.12 is the provision that kind of obliges platforms to provide access to what the DSA says is publicly available data without undue delay and at best in real time. And this tends to happen through application programming interfaces, so-called APIs. But there's also platforms that do not provide these interfaces, which instead just, after you apply for this data access, they tell you, okay, you can now scrape, basically. So there's a kind of, platforms kind of implement this differently. And to do that, however, you kind of first need to apply for data access. And yeah, I kind of looked it up just today, basically, because the platforms actually have to publish the information on kind of how many researchers actually apply, or like they committed to publishing it under Commitment 26 of the Code of Practice on this information, which is now a Code of Conduct, actually. So LinkedIn has received 73 applications, TikTok has received around 600 applications for the API. YouTube has received around 160 applications, and Meta, which does not kind of say, or like they say that it's globally, where the other kind of platforms kind of disclose this for Europe, has said it's received like 600 for like its content library and 160 for its API. So it's actually quite a few kind of applications that they've received, even though like it's over the last 2 years, which basically means that, yeah, like some people request access, the data access, but we can't really know, like, you know, is it the same researchers who request access multiple times because they get rejected, right? And so like, it's not like there's like a huge kind of wave of researchers applying for data access. And then we, as a DSA data access collaboratory, DSA 40 data access collaboratory, we have like a tracker where researchers can voluntarily share all the information they want about the application that they kind of received. So we ask kind of when did they apply, when did they receive a response, how was the response motivated, if they want they can just also share the email threads, right? And we only cover like a very small part of this, right? So we have like 19 applications to X, 12 to TikTok, and overall just 38 kind of valid responses, even though we have like 300 people who visited the tracker. So for TikTok, for example, we cover roughly 2% of the applications that they receive. But even based on the data that we do have, we can basically kind of summarize that data access is not working as it should. And I think this or like at least 4012 data access is not working as it should. And this comes down to a few reasons. The first one is the modalities itself. So for one, we don't really know what does it mean if data is publicly available, right? For example, for YouTube, you would assume, okay, it is the YouTube video, right? And it's the comments on the YouTube video and potentially the amount of likes, right? And was it uploaded? Turns out the YouTube API only gives you the metadata. So only the description, the date of upload, but the video itself, YouTube actually actively discourages you from downloading the video. That's a bit strange, I would say. And then like with TikTok, we've had multiple experiences where the TikTok API does not return data. So the most kind of sus kind of occurrence was before the Trump election. So exactly 7 days before the Trump election, the TikTok API did not return data from like the 13th to the 20th of January, or like not even the election, the inauguration. So that was weird. They did fix it after kind of we came to them. We were like, what is going on here? But so like we also have issues with the functioning of the APIs. They tend to be not so well documented. So actually most of the documentation actually comes from researchers who then provide kind of tutorials for other researchers, which is also not the way it should be. And then we also have a big issue with regards to validity, in a sense that we don't really know if the data that's coming out of the platform, out of the APIs, actually corresponds to the data that the users see. And actually, we do have kind of reasonable reasons to believe that there might be some kind of validity issues. If they're structural or not, it's difficult to say, but as far as I know, there will be even soon be coming out another report which will detail even more issues with the validity of the data. So first, basically, the modalities itself do not work as they should. Then I already kind of quickly touched upon the processing of the requests, right, which are complete overkill for publicly available data, which should be granted with undue delay, right? So Meta, for example, asks you 48 questions that you have to reply to, including your programming knowledge, which does not, like, it's not covered by the DSA. It's like relevant information for data access. Snap, for example, only asks you 8 questions. Then they kind of, through a repeated process of asking you questions back, force you to narrow down your purpose further and further and further, so that you like are really stuck to like one, in the end, a rather arbitrary kind of research question. And if you kind of deviate from this, you potentially open yourself up to liability. Then we also just have a lack of knowledge among the research community right now, right? So like people don't really know that this access exists, for one, and then also they don't know kind of what kind of reference they need to make, right? So like Since all the access needs to be granted to understand, identify, or detect systemic risks inside the European Union, this is also not really known by many people. And so this might be, for example, one of the reasons why many applications are not granted. And then also, like any kind of forum for any form of constructive engagement with the platforms. The engagement thus far has been, not really there, right? So it's always it's not proactive. It's actually the opposite. It's always researchers that have to come and first have to complain to the Commission and the platforms that anything changes, and there's no kind of good way to kind of engage with them in good faith, which is a kind of a big problem also. These would be kind of my four biggest points, but I think if you just ask me long enough, I'll probably be able to list quite a few more issues that we have with data access also.
Thanks, Elka. Yeah, sometimes it feels like the list is endless, and really does, the way you've described it, sound a bit like quite amazed to even get through the process to then get denied on the other end. So, Patty, I want to ask you, there is big talk about a delegated regulation. Can you tell us a little bit about what that is, whether you see, is there a potential that that solves some of these myriad of issues that Elka has raised? Why is it important? What is hinging on this delegated regulation?
Yeah, thanks, Brandy, and Elka for those comments as well. So the delegated regulation is about a separate part of Article 40. Some of you may be familiar, but just to clarify, Elka is describing Article 40.12, which is already in force and has been for quite a while now. And the delegated regulation is about implementing another part of Article 40, which is not yet in force. And this relates to data which is not necessarily public, right? So that's an important distinction. And the other important distinction is that procedurally, this is going to be enforced by our dear DSCs, the national regulators. And that potentially is a cause for optimism, because it's not just you versus the platform, right? But there is this, this authority acting on your behalf and in the researchers' interests in negotiating the access. So those are important distinctions, and that's one of the reasons why people might still be optimistic about this. By the end of the panel, I think we can see whether we're still as optimistic as we might have been maybe a few years ago. But I thought it'd be good to just describe a little bit where we are currently in the implementation process. So I'll talk a little bit about the timeline and then what we've seen so far in the draft, because this is a topic we've been following quite closely at the DSA Observatory. I was myself contracted by the European Commission more than a year ago now in advising on the drafting of the Delegated Act. Since then, there have been quite a few delays in the finalization of that work, but we're nearing the end. I think that's where we seem to be. So we had an initial call for evidence in the spring of 2023, so quite a while back now, 2023, where there was quite a lot of attention from the research community in Europe and abroad responding with inputs to the Delegated Act. I produced for the Commission a summary report, which you can read, that kind of gives the overview of concerns that people had at the time. The Commission then took that feedback and produced a draft that was published last fall. Then they did, and that's quite exceptional for the European Commission, a second round of public consultations, to which you can also see the responses. And since then, the DSA Observatory has organized 2 workshops where we got researchers together, first to discuss, what do we think of this Delegated Act, where do we think it can be improved, and then more recently kind of preparing for, starting to draft our applications as we're nearing the finish line here. Because what we're hearing these days, although none of this is, I think, publicly confirmed, is that we can hope to see a final version of the Delegated Act, hopefully in June or so. Keep in mind, though, that won't be immediately active from that point. There will likely be a period before it enters into force, meaning that actually submitting your applications will be possible maybe by the end of the year, right? But then, hopefully we'll have, by the summer, a definitive text which can serve as a basis to start, sharpening those knives and preparing those applications. So that's kind of where we're at. So let me then talk a little bit about what is in the Delegated Act so far. Obviously, we don't have the final version yet, so there is still some known unknowns, but we do have this draft version to consider, which already has some, I would say, good and bad and absent elements, which I'll discuss. So there are some some things that are just good to have confirmed already in the current text, such as that there is strong language here indicating that NGOs are in scope potentially, that the concept of research organization isn't being narrowed strictly to universities, although of course NGOs will have certain standards applying to them, such as having a significant research task and activity. But the possibility of being an NGO and applying for access is acknowledged in the draft text, as well as that for non-EU organizations, which is another kind of open question. So those are, I think, clear wins for the research community. Another win is that there is text in the recitals indicating a relatively broad interpretation of what data can be requested. Because if you look at the text of the DSA itself, the examples it gives are really quite minimal. It's about view counts for moderated data, and that's it. Recital 12 of the Delegated Act gives a very long list of all the different kinds of content moderation data, content curation data, and many other things, indicating that it's not as narrow as that really small example in the DSA indicates. So that's another victory. Some of the, let's say, trickier aspects have to do with two new elements that are introduced. First is data inventories. This is a concept that the DSA does not mention, but is new to the Delegated Act. This is the idea that the platform should publish an inventory of the types of data that they have that might be eligible for a request. And this is an attempt to address something that researchers have been raising, which is the problem that it's very hard to design a request until you know what the platform has, right? It's a bit of a catch-22, and the inventory is supposed to resolve that. But there are kind of different opinions about this. One of the concerns I have is that the platforms could use this inventory to kind of narrow the potential scope of Article 40, which is ultimately extremely broad, right? So that platforms will, if they were producing these inventories, are very unlikely to be very specific or to be totally comprehensive in what they list. And it would be a shame if researchers would try to request things not on the list and have it be rejected on those grounds. So we're hoping that if that inventory thing is included, that it'd be very clear that it's not exhaustive of your options, right? And in the discussions we had in our workshop, we kind of discussed parallels to, let's say, freedom of information laws for government, right? Where another potential solution, rather than trying to get everything into a data inventory, is to just do multiple requests over time. This is a classic strategy for journalists doing freedom of information requests. You first send a request asking, what kind of data do you have on this topic? And then you send a second request requesting specifics, right? So these are the kind of strategies that over time might help researchers clarify what's available without necessarily depending on that inventory system. So that's one of the kind of I would say, more controversial elements of the Delegated Act at this point. Another one is access modalities. That is a term that the Delegated Act regulation uses for the types of formats for disclosure, right? Where on the one hand, one is that there is a direct transfer of the data to the machines of the researcher, which would typically be used for less sensitive data. On the other end of the spectrum, for the most sensitive data, the Delegated regulation talks about secure processing environments, also sometimes referred to as data vaults, or some other terminology is used. But then there's a machine operated by the platform or a third party that regulates and constrains how the researcher can use that data. Now, the Delegated Act only mentions these two options, though there are some probably interim options that can still be explored, right, such as an API-based access, for instance. There's also the problem that an open question is who is actually going to provide these infrastructures, right? For instance, these secure processing environments, where one discussion we had during our workshop, based on the initial experiences also with Article 4012, is that the solutions that platforms are currently providing are like almost farcically bad and unusable. And so the idea that platforms would be providing these things seems almost unacceptable. So we had very serious discussions about, can we find third parties that are willing to provide that infrastructure in a usable way? Or it should also be a strategic priority to design your requests in a way that you avoid requesting that level of sensitive data, trying to argue already in advance that no, this is not sensitive and we don't need to use a secure processing environment, because the default outcome suggested by the Delegated Act of platforms providing them seems to be very far from ideal. Now, one final point, which I think is a real red flag, which has been raised by several people, is on dispute settlement. Because there are dispute settlement mechanisms included in this process. There is, for instance, an independent advisory mechanism that can be used for like consulting independent experts, but also real mediation if the platform really disagrees on the requests. One thing that's been discussed as problematic by various researchers is that the researcher isn't really involved in this process. It's really the DSC versus the platform. The platform can initiate mediation, but the researcher cannot, right? And if the platform initiates mediation, the researcher isn't necessarily at the table during those discussions either. So that's a real concern we have, that it's very plausible that at the end of the road, after a request is processed, that it takes on a form that is not actually adequate to the researcher's needs. So we really think it's important that the researcher is kind of involved throughout that process. So that's one thing we hope will change in the final version. So I talked a little bit about the good and about the bad in the delegated regulation, but let me also mention the absent, because the delegated regulation is also significant for what it doesn't do. And I think one of the main things we see missing is real concrete guidance on the substance of the evaluation. So here I'm talking about things like data protection compliance, but also the carve-outs that the DSA has for broadly trade secrecy and the security of the platform. So trade secrets, you probably kind of know what that means. Security here means the platform refusing to disclose data because, this is an argument you often hear, that, for instance, describing their moderation procedures in detail would allow bad actors to circumvent those procedures, right? So that's the kind of security arguments they could also use. So on all these points, user privacy, trade secrecy, and security, the platforms can kind of try to push back and minimize access. And generally, these are things that the DSC needs to be able to evaluate. How they do that, the delegated regulation is more or less silent on. I mean, we could be happy that it doesn't actually say anything bad about these things, consider the alternative, but still there are many open questions. And I think that might also kind of bring us more quickly to our next speaker, because procedurally this means that all these questions are going to fall to the digital services coordinators. So I think a lot of the researchers right now are looking to them to understand how they are going to start interpreting these things as it goes into force, assuming that the final version of the delegated regulation doesn't clarify these issues. It's really going to fall to the DSCs to clarify how those very, very crucial provisions are interpreted. So that's my whirlwind tour of the delegated regulation. Another thing I'll just briefly mention that we discussed in the workshop is kind of also responding to Elka's point, a bit of a vibe shift, let's say, which has been happening, I think, in platform governance in general, very different stances from the industry towards regulation and towards civil society coming from the US under the new Trump regime, and what that means for data access, and maybe also some expectation management, some adjustment of expectations, and some adjustment of strategies. But that's maybe something we can talk about later as well. So thanks for your attention.
Thanks, Patty. We'll definitely talk about that later. So Kirsty, of course, as Patty mentioned, it is a lot of this is falling on the DSCs, right? To think about how and establish really how this vetting process for researchers works, will work within the DSA. I also want to call out something I think was quite nice that you and your team did have also taken the approach of also consulting with the research community and looking to the research community to give you answers to some of these open questions about, what kinds of researchers would be interested in possibly applying for data access, what those applications might look like. I thought that was a really interesting approach that you and your team have taken. So I was wondering if you could share a little bit about that, and just in general, how are you thinking about this at the moment? How are other DSCs thinking about these questions?
Sure. There's a lot in there. I suppose to start with, just to explain why you might see the Irish regulator mentioned a lot in the context of this, is that when it comes to processing vetted researcher applications, ultimately the final decision is made wherever the very large online platform or search engine is based. And 15 out of the 25 are based in Ireland, and they also happen to be, I would say, some of the most popular ones in terms of data access applications. So we do have quite a, I would say, outsized role in this process compared to a lot of other aspects of the DSA even. And just to kind of touch on, I suppose, where we're coming from with this as an organization, The vetted researcher team that's working on this is actually based in our research unit within Comisión Man, and we have a lot of researchers on the team, including myself, so I think that's been quite useful in that we're able to often speak to, hold on a minute, that's not how researcher funding works, or this isn't the way these things work in the real world. So that has been, I think, a useful aspect we've been able to contribute. And we also have somebody on the team who's come from a health research background, which I think is quite useful in terms of, and Paddy kind of alluded to it, that there can be a bit of a, oh, this data is just so sensitive, there's no possible way that we could ever safely share it with a researcher. And so it does help to have somebody on the team who says, well, if I've managed to send genetic material to China, I think we can find a way on this. But it does introduce, I suppose, a lot more complication. And I would say in terms of Article 40, Article 48 lists the criteria for becoming a vetted researcher. And I would say by far the most complicated one that causes me the most stress is 48D, which relates to data security, confidentiality, and essentially how are you going to maintain that. Data protection obviously comes into that in a big way, but in a way too, there's a lot of previous precedent with GDPR and conducting research in a GDPR compliant way, which might not be necessarily, I know from my research background, wasn't necessarily a big part of my research, so there might be a bit of upskilling or capacity building required there for certain researchers, but it does exist. I think where it does get a lot more complicated to that question of what is an appropriate modality or what is an appropriate level of security, and especially when you're likely to have platforms disagreeing on what their version would be of an appropriate modality. And just to kind of echo Paddy's point on that too, around data minimization, I think that's a really important point on this, that realistically, we look at this as a very risk-based approach. So the obligations that apply to your specific data access application will very much depend on what is the sensitivity of the data. Is there personal data involved? Is there confidential data involved? And again, thinking to points like if it is something like content moderation data that could be used by a bad actor, even just being very clear about, well, how will this be used? How will it be published? What will be disclosed at a later stage? Those kinds of details all become very relevant. And so I think wherever possible, if you can actually reduce down your ask, if, for instance, you don't actually need to know exactly where people live, you just need to know that they come from a certain country, that's a better way of going about things. So it's really about, I suppose, trying to understand the risk that your data might pose and whether it's absolutely necessary for your research question. In terms of, I suppose, a broader level, it is very true that once the draft Delegated Act came out, there were areas, particularly with the assessment, where DSCs were going, okay, we're not going to get a nice clear guidebook here on what we need to do, so we're going to have to come up with that. And a lot of the focus in the last 6 months has really been on collaboration between DSCs and also harmonization. What we want is a system that is the same, that your application will be treated in a similar manner wherever it ends up. For those of you who aren't aware, you can, if you're an EU-based researcher, you can apply for an initial assessment with the DSC of your research organization, which we would encourage, to be honest, because there's sort of national knowledge around institutions and funding and various bits and pieces that get a lot more difficult if you don't have familiarity with how that country does things. So that is one point, and that's been a big point that we've been looking at as DSCs, making sure that if somebody does make an initial assessment, the steps that would be applied by that DSC are the same as they would be by the DSC of establishment. So we've been working on, I'll call it an MOU for now, we'll see what eventual form it comes out as, but we've essentially been working on those documents on how do we work together? How do we conduct things like initial assessment in any division of labour? And I think most substantially, how do we conduct the assessments? So I would say that you should expect a unified approach from DSCs, both in terms of quite detailed researcher guidance. We're very, very clear on, we want people to understand what it is they have to do. It's going to be very frustrating if you're getting rejected and you don't understand why, or you didn't understand what you had to provide in the first place. So we really want to make clear, look, this is what we're looking for in each criteria, and here's guidance on how we think you can best do it. I would say what we're looking at is something that isn't just going to be an ad hoc process, that it will be, it's something that's been given a lot of thought and development and a lot of legal input as well, obviously, because we have to fulfill the sort of legal obligations with that. And while, like I say, Comisiún Man does have a sort of outsized role in this process, I would say we really have had great collaboration from all the DSCs, and there is a real sense of this is a project we need to work on together, and it's only going to be successful if we do work on it together. And just to touch on the researcher survey as well, so we had 116 responses in total, and I will say we very much targeted researchers who have some familiarity with this already. So it wasn't a scoping exercise of who knows about this. It was very much people who are interested, perhaps likely to apply, have maybe contributed to the consultations on the Delegated Act. And of the 116 responses we had, most were social science, there was some computer science as well, and 80% were academic and 12% were NGOs. So again, it'll be interesting to see how that plays out in the final piece of things. A point that might be interesting on the 4012, so the public access, we did ask if they had engaged with or applied with existing programs, so like applying for public data from one of the platforms with the programs they have at the moment. And only 32% said yes to that, which I thought was, I know myself and Brandy were discussing this beforehand, is quite low. And that perhaps points to what's available there, that, you know, a lot of what's being offered isn't necessarily what's required to answer some of the really important questions that are coming out from the research community. And also there's very different obligations associated there. So I would say that is something that we have a bit of concern about around, you know, this is in a way a different data access regime. It's likely to have a lot higher standards, particularly for a lot of data asks. And if somebody's used to, I don't know, maybe working off data they've gotten off GitHub, it's going to be a very different beast in terms of that application and even the institutional support that would be required to make sure that you're able to show that you can utilize that well. And I'll just finish with, of our 116 respondents, they were planning close to 600 applications. So that's because you have to make an application for each data access request. So if you want data from from Facebook and Instagram, that would be 2 separate requests. So there is the possibility for an individual researcher to make many different requests. And to Paddy's point too, they could be phased over time, or it might be you're asking for something smaller at first and then you're asking for something in depth later, you know, so there's a lot of different variations of what that might look like. I will say also most of those were for Irish VLOPs or VLOSs, so you can see why we have a lot on our plate at the Irish DSC at the moment. And 65% of those respondents expect to make an application in the first 6 months. So there's a lot of pent-up demand. People are raring to go on this. And yeah, I suppose I'll just finish by saying, you know, this is a very, very complicated piece to enact. I think it's taken a long time, and I understand there's probably some frustration with that and with the sort of radio silence on it. But I think you should expect to see quite a lot happening very soon, and hopefully we'll be able to provide strong guidance. And I'll just add to, don't expect it to all run smoothly at the beginning. You know, I think there's a lot of unknowns with this, and there's a lot of, we don't know, for instance, how platforms will respond to things and what perhaps resistance we may encounter. And also, I can just say on behalf of ourselves too, we want to make sure that all of reasoned requests, but particularly the first ones, are airtight in terms of they've been very well gone through. We understand that they're setting precedent for certain future cases. It might take longer at the start, but we are very committed to making this a program that's successful for researchers and that will allow people who are compliant or who meet those criteria 48 to access the data that they legally have a right to.
Godspeed, Kirsty. Matthias, one thing that has changed since 4 years ago, talking about data access, is the geopolitical landscape that we find ourselves in at the moment. Of course, we saw Joel Kaplan from Meta immediately referring to fines that came from the DMA as tariffs. Using that language. So we have this constellation, right, of American companies, the Trump administration, the European Commission. Talk to us a little bit about the politics of data access at the moment, and how you see that constellation.
Thanks, Brandy. No, that's a great question, and I think Paddy already referred a little bit to the vibe shift that has happened in the past couple of months as well. But at the same time, I think like has a lot changed. Like yes, but also no. I think platforms have always had this really big baseline level of resistance against anything related to access to data. I mean, we have been discussing exactly this indeed like 4 years ago, because there is literally zero incentives for them to really do this properly or be proactive about this as well. It is a net cost for them. So there's very little incentives to start building infrastructure, APIs, data vaults, whatever could possibly be needed to do this well. If there is no cost involved, and for instance you would allow researchers just to scrape, there is still reputational damage that is likely, that is going to come as a result of of the research. And then for both things, there are indeed things like GDPR challenges, trade secret challenges as well, which brings up lots of legal potential problems for them. So I think in that sense, like there has always been this reluctance, just as there always has been a big type of reluctance among any type of US administration versus any type of platform governance that the European Union has tried to set up. I still remember sort of like the headlines of the Financial Times 10 years ago, where basically Obama was sending threatening letters to the European Parliament when they were contemplating sort of a resolution on the breakup of Google, for instance, as well. At the same time, as you already mentioned, like a lot really has changed as well. And I think it did start, I think sort of with the framing by Meta in particular, where Zuckerberg was saying like the US government really needs to defend us from censorship abroad, which was then later on translated indeed by Joel Kaplan saying not only DMA fines are tariffs, but he was in Brussels a bit earlier where he was saying any type of regulation is potentially a tariff as well. And then, of course, then everything in terms of enforcement actions related to the DSA become part of this much bigger geopolitical game as well. And we can see that this is, I would say, like the amount of interference is unprecedented. It is coming from the White House, where you have this directive to prevent the unfair exploitation of American innovation, which I think is a really interesting. There's like a PhD title just in that sentence, right? It's coming from the FTC, it's coming from the FCC, it's from the State Department that is mobilizing diplomats as well, asking them to literally send examples of how European governments are, quote unquote, trying to censor US citizens. There's this also what Paddy, for instance, has been referring to as well, although the FTC has threatened to, with unnamed responsive actions, if platforms are coerced to hand over data that is covered by intellectual property laws, for instance, as well. So I think that is really a vibe shift for sure. But I think the biggest impact of all these changes is really on who can potentially apply and make use of Article 40 and the data access mechanism as well. Because what we're seeing right now in the US is the total erosion of academic freedom and scientific autonomy. And entire fields are disappearing. The whole field of disinformation studies, where there was a very robust scientific community in the United States, has been wiped out in the past 2 months, I think. There is funding for the NSF, the National Science Foundation, which has been slashed with 55%. There's like a list of keywords that Doge has used as well. Like the examples are, there's so much, and it all leads to self-censorship, obviously, right? Like not only for, there's people who were thinking, especially in the US, and indeed as Paddy has highlighted, like one of the key wins was of the Delegated Act was that non-European researchers would be able to actually apply for access using the Delegated Act. But if there's no funding in a given field anymore, then there's just nothing going to happen. And we see also even that having an effect on researchers in Europe, which are changing titles of research projects, which are more hesitant about starting cooperations with sort of US universities as well, actually. And then I think, coming back also again on the political level, there is a very careful sort of line that European Commission is taking, where it's very clear where they say DSA enforcement is our own prerogative. We're not going to make that part of any grand bargaining or deal, be it in the trades field or national security. But what you will see, and in the end everything is political, is that it probably will have an impact on timing of enforcement decisions. Like there's a really important NATO summit coming up in June, for instance. There is the end of the 90-day sort of periods where the tariffs are being frozen, that is ending end of July. And I think sort of there will be, if you are the president of the European Commission, those are key dates that you have in the back of your mind, and you don't want to rock the boat too much in terms of enforcement actions, being very firm on very potentially Article 40.12 investigations about finalizing the X enforcement case as well. And I think in the end, what platforms obviously see as well, they have a potential backup now, political cover and backup for non-compliance for some companies, obviously, as well, where they can see like, well, even if we are being fined at the end of the road, it's what Zuckerberg has been saying, we have a very strong ally in the US government who has potentially our back on some of these topics. And that is definitely a vibe shift.
Yeah, wow. And ultimately a fundamental question about European sovereignty as well that I think that this raises. I'd love to hear other perspectives on the vibe shift. Actually, this question I think is a very interesting one. And Matthias, you talked a lot. I think a lot of what you said was applicable to DSA enforcement writ large and enforcement of European regulation writ large. Especially, I think the digital aspect of this is a little bit unique. Digital regulation, in my mind, is a little bit unique in that we're talking about almost all American companies, right? When we're thinking about DSA enforcement, which is slightly different, I guess, than other areas of European regulation. But I'm curious about views on this question about like the geopolitical changes that we're seeing and how that affects data access in particular. Like, what is it about transparency and access to data that is so fundamentally threatened by what's happening right now?
I guess I respond shortly or briefly. Yeah. I actually don't know if like Mark Zuckerberg and Joe Kaplan aren't a bit overconfident. I mean, you could see like also the kind of was it the FTC investigation or like the crackdown on the monopoly? So like if they were like completely covered by the Trump administration, like they would be completely covered by the Trump administration, but they're not, right? So I think that like we will see if they actually will be able to operate under complete impunity, just not complying to the DSA. We will also see, I think that like talking to the Commission, we will see that actually the investigations which has progressed the furthest is the one on X. And at the same time, we see kind of Elon Musk slowly also leaving the White House, kind of less often appearing with next to Donald Trump. So we see if like they'll be so good friends after all when the kind of fine for non-compliance comes. So I guess we'll have to see about that. But I mean, in the end, like of course, like the DSA I mean, and I think then the question becomes a bit like how you interpret the systemic risk also, right? But I guess that like these platforms don't just create systemic risks, but do also kind of represent the systemic risks in themselves, right? If you look at X, for example, which just turned into like a right-wing kind of sewer pit, like within months, right? So basically one very central network node just failed. right? Which was kind of relevant for a lot of communication, right? So like you could argue that like the DSA potentially sets out a very different interpretation of like what a healthy like digital ecosystem looks like, where these platforms might not play such an outsized role anymore. So like we'll see, but in the end they also kind of have, I think 25% of the revenue comes from Europe. So I think it will be hard for them to just kind of shrug and be like, yeah, okay, come at us. I think that this is not what we're gonna see, but there's probably gonna be a bit more kind of, yeah, like varied response.
If I may, I have some thoughts as well. I'd also be curious to hear what you think, Brandy, if you have thoughts also. But just to respond to some points here, because we discussed also in our workshop some of these points, what this also means for kind of researcher strategy, let's say. And I forgot to mention just there, but our workshop report just went online this afternoon, co-author with John Albert, who's in the room here. So check that out. But some of the points we discussed there were, you know, maybe Matthias is right that, you know, platforms are always going to be ready when we move from, like, let's say a voluntary environment where they could like perform but not really implement data access to a regulated environment, that they're always going to pull out the lawyers and really kind of shift gears. So maybe we were always maybe a bit over optimistic in that sense, but I think we are in a moment of perhaps expectation management. Right, it's a conflict I felt myself. Also, talking to other researchers, where maybe a year or two ago, we were all about like awareness raising, spreading the word to like non-DSA nerds that this exciting new provision was coming, and that empirical researchers, like reaching out to them that this is an interesting thing to consider. And you know, I think we were successful in that endeavor, and you know, I was definitely impressed to see how many people responded, for instance, to these consultations. It's really been out there. But now we're reaching the point where you have to ask, are we promising too much? And will it be disappointing when it proves to be, you know, a slow and difficult process once it becomes implemented? And there's a balance to be struck there, I think, in also, like you say, developing initial applications that are airtight and building on those processes, and then maybe also showing, not telling, the value of this provision. Rather than, you know, overhyping it. So that's one part of it. Practically also, you know, we talked about lawyering up and being ready to have much more adversarial stances here. You know, if we can anticipate the platforms to be even less, maybe performatively kind of complying with this provision than before, then the step to litigation and to court might be quicker. And we should be ready for that. Also defensively, and that's kind of a final point where, you know, what we've seen, unfortunately, in the US, and groups like Brandy's Center for Independent, Coalition, for Independent Tech Research have been excellent on this point. We have seen a lot of also personal attacks on researchers as part of the big tech and, you know, Donald Trump playbook, right? And so thinking about ultimately legal strategies, if it gets to the point like we saw the lawsuit of X against the CCDH, having those systems in place or knowledge in place, as well as, you know, in terms of communications and politics, that, you know, how these endeavors are framed. I think the strategy on the kind of the Silicon Valley side at the moment is to frame these research projects as a form of surveillance. Right, it's the censorship industrial complex narrative in which the researcher is basically an arm of the state surveilling the users, right? And I think one of the ways to kind of counteract that is the idea that this is not surveilling users, it's monitoring the platforms, right? That's like one of the distinctions that can be drawn. And it's not censorship that's being conducted, it's in fact, it's a form of expression, right? This is actually improving knowledge and holding tech accountable. So thinking also discursively and narratively about how we can position research and counteract these kind of slanders is part of that work too, in this aside to just lawyering up and being ready for potentially, unfortunately, abusive claims. So those are some of the strategies we discuss also in our post.
Sure. Yeah, I find it quite ironic, the idea that a surveillance operation of users, it's not social media in its current business, right? So it's a bit, it's a bit interesting. And the censorship framing is also a bit interesting in the sense that, you know, all of the examples that Matthias gave about the censorship writ large of academics, of researchers, that's happening not only in the United States, but there have been, several European academies of humanities and sciences over the last few months that have released reports on declines in academic freedom in Germany and the Netherlands, for example. And so it's definitely not only an American problem. So when I think about that censorship piece too, it feels to me very clear that the call is coming from inside of the House rather than, it's this narrative that's been used, weaponized against the research community in a way that is completely absurd. I think the data access and transparency piece, and where that to me feels really interesting within the whole geopolitical framework, is really, it shows how much of a threat that is. I think this is in some way a success challenge, maybe, if I'm being an optimist, in that data access and transparency is so fundamentally threatening that now it's facing this huge political backlash. And just as you say, you see the, technology platforms essentially, it was a very different vibe 5 years ago, 6 years ago, when, you'd be in conversations with platforms about data access, and sure, it was the similar sense of promises being made that never panned out. But now, there is an active attempt to unite a hostile administration to back the, in the case of the DSA, I think non-compliance or, obstructionist behavior that we're seeing from the platforms. And that's because the transparency that the DSA foresees is such a fundamental threat. And I think that in itself is very telling. I think that's, to me, why these enforcement cases are so important, is because if we see regulation that genuinely aims to bring real transparency that can lead to accountability coming from Europe, and in turn, we see that when American companies use the power of the US administration to try to squash that, where does that leave us? Like, that's the question that's in my mind, right? What does that mean for, UK's online safety bill? What does that mean for Canada's online safety bill? What does that mean for our ability to actually have accountability from some of these companies? To me, those are some of the key questions that are sort of in my mind when I think about this.
Actually, if I may, Brandy, just one more point on this, because there are lots of discussions about the geopolitics of the DSA and the enforcement dynamics at the European Commission, and also a lot of speculation about what directions that may take, the extent to which these pressures are influencing their enforcement strategies. And it's easy to generalize about the DSA and then to forget that Article 40, the European Commission doesn't have that much of a role to play in the first instance, and it's down to the DSCs. And this ties into a kind of a broader, criticism of the DSA that, its enforcement is in the hand of this extremely political body, the European Commission, that's doing international trade negotiations and foreign policy at the same time as it's trying to do this technocratic governance. And so what an interesting kind of quirk that then, of all these VLOP obligations, the only one that's under the DSCs, which are required to be politically independent, is Article 40. So maybe that's also our saving grace here, that this is, we would expect to be a much more independent part of the governance system. Yeah, fingers crossed.
I might just add to that as well. I think it's important to remember why Article 40 is there in the first place, in terms of it's not just, wouldn't it be nice for researchers to have some access to data? It's fundamentally there for the purposes of investigating, studying, putting more understanding on systemic risk under Article 34 and 35 of the DSA, where the platforms have to provide their own risk assessments. And so I think there is, to me, that's why we should expect this to be contentious and complicated, because ultimately, if a platform is non-compliant with Article 40 of the DSA, that's a certain problem for them. But at the same time, if they are compliant and the result of that compliance shows that they're not compliant in other areas, that might also be a problem for them. And I think that's fundamentally the issue here, and it's to Brandy's point as well, that this is forcing transparency in a way that hasn't been very forthcoming so far. So I think that is an important point to remember, that this is in my mind, one of the most important provisions of the DSA, and that it's sort of underpins a lot of the evidence base for actually understanding what systemic risks are and what good mitigation looks like. And just to that point on enforcement too, I think ultimately if a platform is non-compliant with what a DSC has mandated them to provide to a researcher, that will end up with the European Commission in terms of investigation and enforcement. But there could quite possibly be some fun judicial reviews and bits and pieces in between before it gets to there. And that's something that we're very, I'd say, as prepared as you can be for these things, but it's something that we're ready to take on as well, and that we very much will defend our decision making, and particularly if we've granted access or said that access needs to be provided, it's for good reason.
Maybe just one sentence to add, like as an anecdote, like when talking to representative of a very large online platform, I'm not going to tell which one, but they were basically saying like we were very confident with the first set of risk assessment reports that we have performed until now, because there was no really benchmark or standard, so we could get away with anything. But, and this is the literal quote, we are now really ready to be hit by the Article 40 bus once it actually comes, because we know then that can, exactly to Christie's point, can really unearth evidence that we obviously ourselves never would include in those reports.
Someone's gonna get t-shirts made, I'm sure. Would love to open it up to the audience for questions. If anyone has a question, yes, please come up here to use the microphone to ask your question.
Thank you for the great discussion so far. To Kirsty mainly, or anybody else who wants to comment. So first, do you expect researchers based outside EU to be treated differently in this fight? And if not, shouldn't we prepare also for a flood of requests coming from outside Europe that are not necessarily good intentioned? Maybe they are there to block this channel. And the second aspect, you mentioned already what we also expect, it will be very contentious, we will get backlash. Can we, those who will formulate this request, somehow prepare for this? I don't know, like get any guidelines or any suggestions from DPCs how to formulate this request in a way that there will be, as you said, airtight? Will there be some sort of cooperation of that kind? Thank you.
Yeah, we definitely will have guidance hopefully coming fairly soon. It'll be post the Delegated Act being published anyway, but that's definitely something that we're working on that point. In terms of non-EU researchers, I think where it will get most complicated is if there is personal data involved, and it touches on that in the Delegated Act as well in terms of international data transfers, and particularly just everything gets a bit more complicated in terms of GDPR, particularly if it's a country that doesn't have some kind of a adequacy agreement in place. So that could likely be quite complicated and maybe a disincentive in some cases depending on what the data request is. I think in terms of anybody who is dealing with personal data, I would be strongly encouraging you to do GDPR training, to upskill in that as much as possible, and to also link in with what your institution offers in terms of a data protection officer and understand what's required as part of that. I think that would be a really strong point. Other than that, I think there's not too much concrete I can say at this time, but I think there's looking at, the data management plan side of things, I'll say, in terms of, as a DSC, what we'll need to understand in order to assess have you got the appropriate measures in place is what is happening at each stage of the data. So where is it being stored? How is it being processed? What researchers are touching it at various stages? What will it look like when it's published? All those details, and particularly the technical details, unfortunately, of what that will look like will be very important for forming an assessment.
Maybe indeed in 2 sentences, like I think if you are a researcher from a country which does not have an adequacy agreement with the European Commission and you want to process personal data, your chances are 0% that you will get them, I think. So the limitation is not like non-EU or non-EU, no, but like it's the adequacy decisions.
Yeah, thanks for excellent panel compliment. So I had a question about this, I think an attack that we can maybe expect on the researcher access also coming from like, yeah, this concern about the surveillance and I am like, I agree there are ways to respond to that, but I wonder if you could still reflect a little bit more on, I mean, I would say also there has been a tradition of also some like not great like ethical practices in doing research of online spaces. You know, like, so that it's not hard to find, you know, like a whole bunch of like published work that, you know, it's problematic. And then I think, so that's one, and that's for the researcher community to know and to understand and to reflect on and to understand how, you know, these types of mechanisms, you know, intersect with that. So then, but the second thing is that I do have I'm an academic myself, so I'm a professor of law. I work actually with Paddy, and so I'm very sympathetic to academic practice and knowledge building, but I don't necessarily think that all our societies like are fully on board with that. You know, I think there's a growing skepticism of the value of academic research and research more generally and producing knowledge. And so, yeah, I think we have to somehow relate to that. I think the US, the current situation is a very terrible and stark kind of illustration of some of those kind of politics. But I don't think, I think we have those types of dynamics also with the Netherlands and also in other parts of Europe. And then getting to the surveillance point, so you can be fully GDPR compliant in terms of the kind of data you collect and what you do with it. And there's been over time, like these types of projects that are, you know, they're waterproof, you know, on like being GDPR compliant. And there's like, actually they did the full anonymization and there's like no personal data. But if you do research that people realize has consequences for later decision making that impact the people, you know, like whose data has been used as an input, you can have like you can say people could have good reasons to be like, hey, what is going on here? You know, why is suddenly, you know, like, is my online behavior being studied and resulting in things that I don't agree with? And so there's something in the fact that the issues that are being researched are very contested issues in our society that creates the issue. So I think, like, I wonder what more can be said in response than saying that there's compliance and the law allows that, or just saying like, so anyway, I'm very curious to hear a little bit more reflection on that, because I do imagine some, you know, like future discussions on that, which should not be fully dismissed.
Yeah, thanks for the question. I have a few things. So I think for one, like, I mean, the access is never not vetted, right? And I think that already, like, for example, this is one of the 48 questions that Meta asks, like, do you have an ethics, do you have IRB approval? And I think that, like, I don't know to what extent you will be checking this also if you kind of evaluate it, but like I think like complete ethical malpractice there should be some guardrails against this. I also would, like, coming back to what you said in like the at the end, basically, with like regards to like, okay, why was my data kind of used for this kind of research, right? I think that, like, I mean, and again, we'll probably see what specific modalities will be proposed in the Delegated Act. But Meta has had a pilot, which we haven't heard anything of really since they kind of announced it and kind of closed the kind of the call. But there, for example, the research project was communicated to Instagram users, like young adults, who could then opt in to this research, right? So, like, depending on the kind of like modalities that you use, there might be ways of actually securing consent of participants to kind of also guard against this issue. And then just on your point that kind of research generally is probably losing a bit of support, I doubt that actually. Because, like, research is always there as a means to kind of like support existing power structures, right? And so it's different kinds of research that get demoted or promoted. So I would also say, like, I mean, we saw this like in like probably bit of a hard comparison, but like there was also research in fascist Germany. It wasn't good research, but they had their researchers, right? So like I think it very much depends on like what kind of research will be promoted, and I think we might, without wanting to draw a clear parallel, but we might kind of see a increased focus, for example, by the Commission also on like child protection, right? Because this is research, or these are things where you can easily argue for like, I don't know, chat control or things like that, or where you can easily argue for age verification, right? This is something that has been kind of actively been pushed by DSDs also. So I don't see that like research generally will be demoted. If anything, I feel that like there will be a shift towards different kinds of research that might be more politically opportune.
Yeah, I'll just add a couple reflections on the question. I think on the piece about sort of attacks on the research community and legitimate critiques of ethical issues in research, that is something, you know, I think actually, you know, with the DSA, there have been very legitimate questions about expression, online expression, right? And we've seen when Thierry Breton, for example, made comments about the DSA and how it could be used to stifle free expression, we saw the civil society community and the research community immediately speak out against that and condemn that, right? And so I actually think that in a way, Article 40 is completely helping to advance free expression vis-a-vis the DSA. It is not the opposite of that. It's not stifling it, right? And I think that the attacks that we're seeing on the research community are not in good faith. In my observation, when there are these legitimate questions, whether it be about ethics, whether it be about free expression concerns, the research community has grappled with those questions, with the nuance of it, right? And I think part of it is being able to hold that nuance and to critique it in certain ways. And what we've seen from those who are trying to, attack the researchers and the community at large, it's been stripped of any nuance. It's been taglines. It's been complete conspiracy theories that are made up. And so when I look at that, I do think for the sake of all of our internal resources and external resources, it is important to say these are the things that are legitimate that we need to grapple with, and these are the things that are not, and to separate it out that way. And on the other point you made about the sort of explaining the value of research to the public, you know, I think about this and also kind of question why researchers, you know, I think there's one way of framing it of saying, how is this research supporting, you know, the public and the public's understanding? And then there's another way of framing it, which is, should the only thing that we know about the impacts of these platforms be coming from the platforms themselves? And I think if you ask the question in that way, most people will say no. And I think, you know, so holding the research community to such a high standard of needing to communicate this value is also sort of ignoring the other part of the picture, which is right now, the only thing that we have been able to know is internal knowledge that comes from the companies, which we know is likely not in the public interest.
Could I just quickly add to that as well? Just on that question, I think it is a very good point, and it is a big difference in something like health research, where you're typically relying on the consent of those involved. And I don't think we should underestimate the potential impact of that. I think it's partly a communications issue for researchers too, of how are you making people understand what you're doing with this data. And I don't know if any of you saw the recent Discord study where there was the big scrape, and it was groups of over 1,000 users, but there's a lot of people out there who are going, my group of, you know, whatever it was, I didn't necessarily anticipate that that's what would happen to my data, or that it would be used in that way. And I would say on this, I think what is important as well is criteria 48E, I think it is, which deals with the necessity and proportionality of the data. And that's typically used just in the data protection sense, but I think it's broader than that too. Yeah. And overall, it really goes to this point of, you know, is what you're asking for, is the outcome of that, is it balanced, is it reasonable? And that will be something that will be part of our assessments as DSCs as well.
And maybe we'll do both questions. We have about 5 minutes, so we'll do the two.
Yeah, thanks for the great discussion. I really enjoyed it. I'm Valentina from the Ada Lovelace Institute, and my challenge right now is to figure out how to implement researcher access to data in the UK. So I was wondering whether you have, what would be your top 3 things you would recommend for other jurisdictions thinking about implementing researcher access to data? Thanks.
Hey, I'm Jonathan Stray from UC Berkeley. Hi, I recognize some names. So I have a question about the mechanics of actual data access. So I have this project I'm cooking up where I want to look at the correlation between speech and political violence, which would require running a classifier on essentially all data that a platform has for the last 2 or 3 years. I don't want that data to be handed over. I do not want to possess that data. That is a huge security and privacy risk, which would be very expensive for me to ameliorate. I don't believe that we will see data intermediaries created in the next, decade to handle this. So as far as I can tell, the only way to do this would be to give the classifiers to the platforms to run on their own data, which immediately raises the issue of how can we trust them. And I think the only way to solve that is you have somebody who is NDA'd up, work with the engineers doing this. Is there any provision for this kind of arrangement under the DSA? Because I don't see another way to do the thing that I want to do.
Well, I'll start with the first question in terms of the recommendations for data access. I know Canada has brought in something specific around data access, and it is quite narrow. And just from a purely operationalization point of view, I would say I could see the benefit to starting small instead of starting with a big beast of a thing that's taking years to get into practice. Now, I can't say much more than that, but just there could be a benefit to looking at how do you maybe start this in a scaled up way that you can gradually build upon it rather than perhaps taking on something as difficult to operationalize as this.
And I would maybe add to that from like the issues that we had with validity, like it's a bit of a big ask to have researchers kind of prepare all this infrastructure, kind of come up with all this. I mean, it is to some extent already existing in like the life sciences, right? They do have already integrated this infrastructure, which you could theoretically kind of onboard people onto, but like my thinking has like really like especially with regards to like data validation and like also maybe providing some of the technical infrastructure for researchers to just use without needing to have a very well staffed kind of IT department, right, at the universities or institutions. So I think it would be great if there were like institutions which would take some of the burden off of the researchers, so that like they could actually focus on doing research and not kind of needing to do all this kind of organizational overhead. And then to the second question, I don't know to what extent like these virtual computing environments could be a solution. So like TikTok implements this virtual computing environment, which gives more access to data than the API does, in the sense that you can also query data from under 18-year-olds through that environment. The issue is that like all queries are reviewed by TikTok, and then the response is also reviewed by TikTok, and then you get a PDF out of it. But I think that like, which is hard to kind of work onto, and it's like a very kind of cumbersome process to go through. But considering the risks that you rightfully pointed out, this might be like one of the ways that it might be possible without like while still being very, very cumbersome. So like I could theoretically see these kinds of questions still being answered, but you'd have to probably work quite closely with the data access provisions or with the data access modalities provided by the platforms.
If I can, briefly, on the first question, I would say the simple advice I would have is maybe try to wait a year and see what happens here. That could be very instructive, So yeah, that might be some teachable lessons there. On the second question, I would generally say that one of the advantages of Article 44, that whole process, is that it's really quite flexible and leaves a lot up to the creativity of the researchers to design what data they want to request and also the modalities through which it can be requested, right? So the Delegated Act mentions these options, but they're not like exhaustive, right? So there is room for creativity there. The Delegated Act also mentions NDAs as one of the possible safeguards. So that is another kind of promising signal. As you describe it, like two issues I might see they need to think about. First of all is proportionality, which Kirsty already mentioned. Like necessity and proportionality are elements of it. So if you're going to request like all the data that the platform has, like is the counter or a possible counter would be like, why not a smaller sample or subset, or can this be done in a less kind of large scale manner? So making the argument for that kind of large end approach would be necessary, I think. And the other point is thinking in terms of, you know, the word which is kind of unexplored legally is access, you know, because a platform should provide access to data. And this is access in a different sense maybe than, you know, accessing the data as such. You're not touching the data, you're getting someone to run an analysis for you. But, you know, I don't think that's too much of a stretch. But so those are two of the issues to kind of prepare on, I would say. But there is a lot of room for creativity, and NDAs are included as an option, yeah.
I'm thinking out loud here as well, so if either of you, you two in particular, I think have a perspective on this. But there is the sort of auditing mechanism of the DSA, and it's something that's come to my mind before in terms of, you know, people questioning what if the data we're getting, how do we know whether it's correct or right or anything like that. So I would kind of question too, is that a potential mechanism to, I suppose, double checking some of these things or having an oversight on what it actually is being required that could potentially validate, you know, instead of having to have full access to a data set like that, but even just understanding, well, what is the scope of what's there? I don't know, I'm brainstorming in terms of that.
I mean, you have the potential of simplicity in the UK, right? Because you don't have the situation where you have the Commission, 27 member states, Irish DSA, 26 other national regulators as well. So in theory, you would be able to fix this through one single law and not like delegated acts, DSA, sort of guidelines from the regulator as well. So I think sort of getting it all together in one cohesive framework, I think that would be very advantageous as well. For instance, all the sort of substantive provisions around vetting of researchers. I think that would be really good to spell out in the law from the outset, for instance, as well.
Right, I think there is nothing else standing between us and a coffee break at this moment. So I want to thank you all so much for coming to this panel, and thank you all to the wonderful panelists for this discussion.